The Supreme Court today handed down a couple of landmark decisions, and it is already stirring up controversy on both sides of the issue. But what does this mean for employers, and more importantly, what does it mean for you as workers? Let's dig in. Hey folks, Mark here from the Rational Workforce. Thanks so much for joining us. Got some late breaking news coming out of the Supreme Court. So just wanted to put together a quick video to cover it, and let's talk about what it means for workers and employers. So let's jump into the news. And this was specifically surrounding a case that dealt with the ability to use affirmative action in college admissions. And the headline here from the AP says it all, right? Divided Supreme Court outlaws affirmative action in college admissions and says race can't be used. Of course, this is a divisive topic, and it certainly has folks arguing on both sides of the issue, including the Supreme Court justices themselves. Some really interesting perspectives and developments that came out of there, and that we've had multiple justices reading their rulings, including Justice Sonia Sotomayor, who was the first Latina that was put onto the court, who in her dissent wrote that it rolls back decades of precedent and momentous progress. And Justice Ketanji Brown Jackson, who was the court's first black female justice, called the decision truly a tragedy for us all. And that's some pretty harsh words you can see here in her quote. With let them eat cake obliviousness today, the majority pulls the ripcord and announces colorblindness for all by legal fiat, but deeming race irrelevant in law does not make it so in life. There were actually two cases in front of the Supreme Court with similar circumstances. One was North Carolina, UNC. The vote was 6-3 in favor of striking down affirmative action. And in the Harvard case, it was 6-2. Justice Jackson sat that one out because she had done some advisory work for Harvard, so she excused herself from that case. But wow, I mean, this is a very big decision, and it's sure to stir a lot of emotions across the board. And just to touch base on that a little bit, we go further down in this AP story, and it talks about a Pew Research Center survey released last week found that half of Americans disapprove of considerations of an applicant's race, while a third approve, and then the balance probably didn't have an opinion one way or another. I'll have to do some additional research to look at that report. But let's see how the media is teeing this up. So this was from the New York Times. Breaking news, the Supreme Court rejected affirmative action at Harvard and UNC. The major ruling curtails race-conscious college admissions in the U.S., all but ensuring that elite institutions become whiter and more Asian and less black and Latino. Now, I think I understand the sentiment behind the Times characterization there. Maybe it's just me, but that sounds profoundly racist on its face as well, insinuating that a level playing field will, or a merit-based approach, or removing these policies will, eliminate the opportunity for folks like this to get into the schools. I don't know. It's a really, really interesting nut to crack. And a lot of the discussions that have been going on is, should it be around race or maybe economic factors that can be a sliding scale or a barometer that helps to address these decisions. But wow, I mean, it's an interesting / maybe slightly shocking thing that we're seeing unfold today, and it's certainly a notch in the plus column of the folks who are pushing for making things more of meritocracy than anything else. So regardless of what position you hold, I think it's important to take a look at what this means. And also, I think it's interesting to note that we probably saw some early signs of this coming up. So earlier in the year, if you remember, the University of North Carolina Med School renounced its own DE&I framework. And we actually did a video on this a couple of weeks ago on the channel. But One of the direct quotes from the school's position on this is, even if the recommendations were revisited in the future, further review and revision be required. So the university stated, given the new guidelines adopted that prohibit UNC from requiring an employee or an applicant to affirmatively ascribe to or opine about beliefs, affiliations, ideals, or principles regarding matters of a contemporary political debate or social action as a condition to admission, employment, or professional advancement. So in that particular instance, there was a pushback on, there were certain curricula, there were certain stipulations that the DE&I team there was recommending that they adopt as either conditions of employment for folks that wanted to work there, or conditions of admission for people who wanted to go to school there. And part of that was stating and supporting the statement that the American medical system is inherently racist. So, there's so many things around this topic that is just incendiary. But I think that decisions like that, decisions like what came out of the Supreme Court today, really bears a lot of thought and discussion. Let's avoid the knee-jerk reactions around it. And, where this comes to roost in the workplace is twofold. One is, you bet this is going to be a topic of conversation and a topic of passionate conversation amongst your workers. So if you're an employee, if you're an employer, absolutely be prepared for these discussions to happen. Secondly, and this is where I have to give my disclaimer, as I'm not a labor law attorney, didn't even play one on TV, but when you think about precedent, and could this potentially open the door for similar legal action or similar pushback or similar concerns in the workplace? It's something to definitely think through. It's something to be ready for. And it's something, if you're an employer, make sure you talk to your resident labor attorney to better understand the ins and outs of the issue. One other decision that came down today that I wanted to just highlight for everyone is that the Supreme Court solidified protections for workers who asked for religious accommodations. This was certainly a far less contentious decision. It was a unanimous decision, and it centered around a gentleman who was continually asked, he's a post office worker, to work on Sundays to deliver Amazon packages. He felt that given his faith, Sundays were made for worship and for family, and eventually quit his job but sued them. And in the decision, the court made clear that businesses must cite more than minor costs, or so-called de minimis costs, to reject requests for religious accommodations at work. So there again is something that you need to know as both a worker and as an employer, that's something that was just come down from the Supreme Court today as well. But it is sure to be overshadowed by this big decision surrounding affirmative action in schools. So we'll continue to cover this. Stay tuned for more. If you like what you saw, click like, ring the bell, click subscribe, do all the things. We certainly appreciate you tuning in, and leave some comments with your input on this decision. It's a biggie. I hope everyone has a great rest of the day. We'll talk to you soon. Take care. Bye.